The floor. You have the floor, sir. Mr. President, members of the court, Germany is not legally responsible for the inferno that has engulfed Gaza. Or rather, it is only responsible through its own breaches of its own international obligations linked to this horrific situation. And it is responsible to the extent that these breaches have made possible or facilitated the grave violations of general international legal norms directed at the Palestinian people, not only within the Gaza Strip, but also in the occupied territories and in Israel itself. It is this that justifies both Nicaragua's application addressed at Germany and also the request for provisional measures which are the reason for the hearing today. I don't think I need to dwell on the question of Nicaragua's jus standi. As you recalled so well in your order of the 26th of January of this year, in referring to the Gambia versus Myanmar case, and I quote, all the states parties to the convention, to the Genocide Convention, have a common interest to ensure the prevention, suppression, and punishment of genocide. These are obligations that are erga omnes partis, and each state party has an interest in compliance with them, including through the institution of proceedings before the court. Mutatis mutandis, the same applies in this case. Germany and Nicaragua are parties to the Genocide Convention, under which they both have obligations and rights that they are entitled to invoke before you. However, and our agent stressed this, Nicaragua's requests are not limited to breaches of the 1948 Convention. They also concern breaches by Germany of its own obligations under the 4 Geneva Conventions of 1949, including the 4th one, concerning the protection of civilian persons in time of war, and the 1966 protocols. And our application also refers to other breaches on the part of Germany concerning other relevant treaties that preserve and protect human rights or concern humanitarian international law. All of these conventions set out obligations that are erga omnes partis. Every state party has a legal interest to ensure compliance therewith, including through proceedings brought before this court. As you underlined in your opinion on the wall, and I quote, all the states parties to the Geneva Convention relative to the protection of civilian persons in time of war of the 12th of August 1949 are under an obligation while respecting the United Nations Charter and international law to ensure compliance by Israel with international humanitarian law as embodied in that convention. End of quotation. Furthermore, as a member of the international community of states, Nicaragua asks the court to find that Germany has seriously violated its obligations under the peremptory norms of general international law in these same areas and sanction it for such breaches, whether we're talking about breaches of prevention and punishment of crimes of genocide or apartheid, breaches of fundamental principles in the area of human rights or humanitarian law, or the right to seek reparations in the interests of the Palestinian people. Here again, the court's findings in Gambia versus Myanmar, recalled in your order of the 26th of January, should fully apply. As you indicated in your advisory opinion on the legality of the threat or use of nuclear weapons, so as I was saying, legality of the threat or use of nuclear weapons, and recalled in that on the wall, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity that they are to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law. In the Court's view, these rules incorporate obligations which are essentially of an erga omnes character." End of quotation. I note that, in any case, at this stage, it is for you solely to decide on your prima facie jurisdiction, without there being any need for you to definitively state, and I quote, to satisfy yourself in a definitive manner that you have jurisdiction as regards the merits of the case. So, members of the court, today you are not being invited to exercise your jurisdiction on the merits. At this stage, it is for you just to indicate the urgent measures, and I quote once again, likely to preserve by such measures the rights which you may subsequently adjudge to Nicaragua. The Court's jurisprudence is based on a distinction between two different concepts. On the one hand, the existence of the Court's jurisdiction, and on the other, the exercise of its jurisdiction, where that jurisdiction is established. The fact that in this instance the Court's jurisdiction is established prima facie in order to rule on the application is without any shadow of a doubt. Your recent jurisprudence amply confirms this, and that is enough also to grant you jurisdiction to indicate the provisional measures sought. It is also enough to rule out the objection that Germany doubtless will rely on tomorrow, based on the monetary gold principle. Even although, par excellence, this is a question that is nothing to do with the existence of jurisdiction, of which there is no doubt, but of the exercise thereof. Even if the dramatic circumstances in the case before you today in no way lend themselves to any doctrinal soul-searching, allow me, Mr. President, to say that I have never understood the value of this so-called principle, even although it was articulated in a case that had quite exceptional features. The Court, on several occasions, has stated that it was attached to it at the expense of intellectual acrobatics that strike me at times as being extreme. If it is just a question of saying that the Court's jurisdiction is based on consent, Article 59, together with the possibilities that the statutes offer states when it comes to intervening, whether they are parties or not, is sufficient for the purpose, to my mind. As you have recalled, citing Judgment Number 11 of the Permanent Court, and I quote, "The object of Article 59 is to prevent legal principles accepted by the Court in a particular case from being binding also upon other states or in other disputes. And it is clear from the latter provision that the principles and rules of international law found by the Court to be applicable in the relations between Germany and Nicaragua, and the indications given by the Court as to their application in practice cannot be relied on by the parties against any other state." End of quotation. But let's say that the monetary gold principles is something other than a short-term judicial invention, and if not superfluous, at least clearly without relevance in this case. And let's take it seriously. There are at least two arguments, members of the court, that should lead you to dismiss it. Firstly, as I just said, at the stage of provisional measures, this question doesn't arise. At this stage, you're not asked to rule on the merits of the legal or factual situation resulting from the violation of the applicable legal principles. What is more, and in any case, it is not enough for the future judgment, and I quote, the fact that it might affect the legal interests of a state which is not a party to the case, for the principle of monetary gold, if such a principle exists, for it to apply. In the very terms used in the 1954 judgment, this is only the case if the vital issue to be settled concerns the international responsibility of a third state. That was the case in the very peculiar instance in 1954 when Italy expressly requested of the court that it decide that the governments of the respondent states should give to it the share of monetary gold normally assigned to Albania. But that is not true of the case before us today, in which there is no, I repeat, no request that is related to any right of a third state. The court's position in monetary gold cannot be used to prevent the court from ruling on an application involving a country that agrees to appear before it. Mr. President, it is clearly the application that in each case makes it possible to determine the vital issue to be settled. In this case, the reading of the application submitted by Nicaragua on the 1st of March allows for no doubts to prevail as to its purpose. It is not to find out whether Israel has breached its international obligations, but whether Germany has breached its obligations. In your order of the 26th of January, you considered that the court is not called upon to determine definitively whether the rights which South Africa wishes to see protected exist. The same applies in this case. At this stage here, the court is invited to decide whether the rights complained by Nicaragua and for which it is seeking protection are plausible. Here again, I think there is no need to waste your precious time, nor to squander the time allotted to us to go into exaggerated detail here. In your wisdom, you are increasingly drastic in limiting the time allowed for the parties to present their pleadings. In the same order, the 26th of January, you stated, and I quote you, that the facts and circumstances mentioned that you noted at the time are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Convention on Genocide, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. End of quotation. As we can see from the facts set out by Daniel Müller, this is all the more plausible, not to say proven, today. You confirmed in your order of the 28th of March that since that time, the catastrophic living conditions of the Palestinians in the Gaza Strip have deteriorated further, and this since the 26th of January. And further quotation, the current situation before the court entails a further risk of irreparable prejudice to the plausible rights of the Palestinian people of Gaza. The measures sought by Nicaragua concern protection of its right to see Germany comply with its obligations under the Genocide Convention, and the protection of the concomitant rights of the Palestinian people, which are directly affected by Germany's conduct. It is a right, and it is also a conventional obligation. Without the slightest hesitation, the same reasoning applies when we turn to the violation of major treaties that protect human rights or that codify international humanitarian law and that I enumerated earlier on. We see this in the horrors of the hell of Gaza that you referred to yourselves, in the abuses inflicted by Israeli settlers in the occupied Palestinian territory, the victims of which are increasingly the Palestinians of the West Bank. Once again, Mr. President, I don't believe there's any need to be a soothsayer in order to anticipate the protests from the German respondent. Yes, the humanitarian situation in Gaza is worrying, and when I say we, it's Germany that I'm talking about, we're worried about it, and we are making this known. But it's nothing to do with us. We're not committing any of the genocidal acts that have been enumerated in Article 2 of the 1948 Convention, nor do we intend to destroy, in whole or in part, a national, ethnic, racial, or religious group, whatever the definition that is given to it, as embodied by the people of Palestine. And I have no doubts that this Pontius Pilate-like stance, with an equally clear conscience, will be repeated when it comes to the violation of human rights and humanitarian law. There are no German soldiers in Gaza nor in the occupied Palestinian territory. It has to be understood, and we can but approve that Israel has a right to defend itself, unless their conscience gets the better of them, and our learned friends show restraint on this, given the monstrously disproportionate retaliation to the Hamas attack of the 7th of October. And as in any case, nothing at all can justify the systematic targeting of hospitals, schools, and distribution of food still being carried out by the rare NGOs still managing to survive in Gaza. In any case, there seems little doubt that Germany tomorrow will say, "It wasn't me, Mr. President, it wasn't me." If that is the case, then it's clearly in the wrong proceedings. The matter before us here has been set out very clearly in paragraph 3 of the application and is repeated in the conclusions of the application. Nicaragua, what is it that it reproaches Germany of? It is not, and there's a reservation there that I'll come back to in a moment, it's not committing genocide in the Gaza Strip or in Palestine. It is that it has failed and continues to fail to fulfill its own obligations to prevent genocide being committed and to punish those committing genocide or involved in any of the acts set out in Articles 2 and 3 of the Convention. It is not accusing it of breaching obligations on parties at war because Germany is not involved in the Israel-Palestinian conflict, nor is it anything to do with obligations specifically concerning occupying powers. Germany is not an occupying power. Nicaragua accuses it of not complying with its own obligations as Germany under international humanitarian law that it must comply with in any circumstances, and that includes its obligation to prosecute, try and punish persons responsible for or accused of serious crimes under international law, whether it is genocide, war crimes or apartheid. Far from doing so, Germany is going ahead with business as usual, or rather, as Daniel Müller explained, business better than usual. Arms sales have not ceased. They have increased significantly. Nor does Nicaragua accuse Germany of pursuing an apartheid policy against the Palestinian people or of denying its right to self-determination. What it accuses it of is providing aid and assistance to the preservation of systematic racial discrimination and the apartheid regime that the Palestinian people is a victim of, and of failing to fulfill its obligation to cooperate in achieving its right to self-determination, and this by providing Israel with assistance, particularly military, that is being used and can be used to prevent the exercise of self-determination. And it's indeed Germany, not any other state, not Israel, that Nicaragua accuses of suspending, of cutting off funding to UNRWA for its activities in Gaza, preventing it from carrying out a vital, irreplaceable humanitarian role in the enclave at a time when that role is increasingly indispensable. In this way, facilitating Israeli abuses and aggravating famine, the lack of water and medical care, and aggravating further the humanitarian catastrophe. The same can be said of the request to indicate provisional measures, and our agent in a few moments will read out the final version. Within the inherent limits of the court's jurisdiction, they all concern and only concern Germany. Whether we are talking about Germany having immediately to suspend its aid to Israel, in particular its military assistance, insofar as this aid may be used in the violation of the Genocide Convention or other peremptory norms of general international law. Germany must immediately make every effort to ensure that weapons already delivered to Israel are not used to commit genocide or are used in such a way as to violate international humanitarian law. Or, again, Germany must reverse its decision to suspend the funding of UNRWA in Gaza as part of the compliance of its obligations to prevent genocide and serious violations of international humanitarian law. These are specific and precise requirements that concern only Germany and that are all capable of immediately bringing relief to the suffering of the Palestinians and the violations of the most fundamental principles of humanitarian law, and also to mitigate the genocidal pressure of which the Palestinians are victim. Mr. President, I don't want to go into detail of Nicaragua's complaints addressed to Germany, but I would like to give a few examples of their autonomous existence as compared to those that might be addressed to Israel if the latter were to accept the jurisdiction of the court, aside from the single exception to Article 8 of the Genocide Convention. But let's begin with this. I've said that except for one aspect, and it's an important one, Nicaragua is not accusing Germany of committing genocide against the Palestinian people in Gaza or elsewhere. What it is saying it is responsible of in the first instance is a failure to fulfill its obligations to prevent and punish the crime of genocide, an obligation that weighs on all parties to the 1948 Convention. This can be seen from the full title of the Convention, its very first article, in which, and I quote that article, the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish. They undertake to prevent and to punish. As the court has underscored with considerable firmness in the very first contentious case on genocide that was brought before the court, and I quote, the obligation on each contracting party, the state, on each contracting state to prevent genocide is both normative and compelling. Furthermore, Germany is well aware of this. It relied on this very duty in intervening in the case of genocide against the Rohingya. And it was even more explicit in a statement made by the Federal Ministry of Foreign Affairs on the 17th of November 2023, and I quote it in English.
Feels it has a special responsibility to contribute to the fight against and the prevention and investigation of any potential genocide, and to send a message that states will be held accountable for all acts of genocide. Genocide concerns us all, wherever in the world it occurs. Well, I have never known how to use this. It was the first time I tried to use my phone.
It is this obligation that Germany has not respected. It is this breach which you will be called on to appraise when you are looking at the merits of the case. And I would also like to note that this is an obligation of behavior and not result, which is what differentiates us from the idea of not committing genocide, as the court has already noted in its judgment of 2007. The result, and this is fundamental, is that the obligation of states parties is to employ all means reasonably available to them so as to prevent genocide as far as possible. A state does not incur responsibility simply because the desired result is not achieved. Responsibility is, however, incurred if the state manifestly failed to take all measures to prevent genocide which were within its power and which might have contributed to preventing the genocide, end quote. I know very well, Mr. President, that a state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. However, as the court has asserted also, this obviously does not mean that the obligation to prevent genocide only comes into being when the perpetration of genocide commences. That would be absurd, since the whole point of the obligation is to prevent or attempt to prevent the occurrence of the act. This duty of prevention of the act arises at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, from that moment onwards, if the state has available to it means likely to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring specific intent, dolus specialis, it is under a duty to make such use of these means as the circumstances permit, end quote. There is no doubt, Mr. President, that where we are today, for any observer, for any state of good faith, the threshold of awareness has largely been crossed. The possibility of a genocide or of an apartheid, the truth of the serious breaches of the most fundamental rules of international humanitarian law have amply been overstepped. Incidentally, at the stage of provisional measures, it is enough for you to determine first the plausibility that a genocide could be committed against the Palestinian people, and also that, or on the other hand, that Germany has not complied with its obligations to employ all means reasonably available to them so as to prevent genocide so far as possible, and the breach of numerous other intransgressible principles which are at stake. You have adjudicated on the plausibility of a genocide in your orders of 26 January and 28 March of this year. Unfortunately, the situation has only worsened since then, as Daniel Mueller has already shown. I would like to add that the acts, which in all likelihood come from the definition of genocide, are committed elsewhere than in Gaza in the occupied Palestinian territories. But Germany has not only not availed itself of all of the means possible, and specifically as one of the closest allies of Israel, to put an end to these probable acts of genocide, but Germany has continued to authorize large-scale delivery of weapons which can be used to commit these acts. Also having to do with genocide, there is one other point. The Article 3 of the 1948 Convention, which you see on the screen, alleges not only that genocide itself, as it is defined in Article 2, but also complicity in genocide is mentioned. And in its judgment of 2007, the court noted and affirmed in very clear terms that there is no doubt that complicity, in the sense of Article 3, paragraph E of the Convention, includes the provision of means to enable or facilitate the commission of the crime, end of quote. Elaborating even further, although complicity as such is not a notion which exists in the current terminology of the law of international responsibility, it is similar to a category found among the customary rules constituting the law of state responsibility, that of the aid or assistance furnished by one state for the commission of a wrongful act by another state. You referred to this under Article 16 of the ILC Articles on the Responsibility of States, which expresses, and you noted it, following the customary rule that follows, and I quote, "A state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if a, that state does so with knowledge of the circumstances of the internationally wrongful act, and b, the act would be internationally wrongful if committed by that state," end quote. And you have specified not noting a reason, and I'm quoting here, a reason of establishing a substantial difference between the complicity in genocide in the sense of Article 3, paragraph E of the Convention, and the aid and assistance of a state in committing such a wrongful act by another state in the sense of Article 16 above. As Nicaragua has shown in its request, and also added to by Mr. Mueller, Germany was aware and continues to be fully aware of the risks that the weapons that they are furnishing and are continuing to furnish could be used by Israel in committing a genocide against the Palestinian people. And it is self-evident that the genocide in question would be internationally wrongful if it were committed by Germany itself. It is extremely urgent that Germany finally suspend their aid and assistance that they are supplying to Israel to this end. This aid and assistance are straight from the definition of complicity set out in Article 3 of the Convention. The urgency of ceasing the delivery of weapons, which would allow Israel to continue its deadly enterprise, has also been recalled recently by the Human Rights Council and by the Special Rapporteur on the Occupied Palestinian Territories. And I would like to quote from this latter in English.
Rapporteur urges member states to enforce a prohibition of genocide in accordance with their non-derogable obligations. Israel and those states that have been complicit must be held accountable and deliver reparations commensurate with the destruction, death and harm inflicted on the Palestinian people. Ms. Albanese called upon all states to, and I quote again, immediately implement an arms embargo on Israel, as it appears to have failed to comply with the binding measures ordered by the ICJ on 26 January 2024. Dans sa résolution
In the resolution from last Friday adopted, despite the negative vote by Germany, the Human Rights Council has also urged all states to continue to provide emergency assistance, including humanitarian relief and development assistance to the Palestinian people to alleviate the financial crisis and the dire socioeconomic and humanitarian situation, particularly in the Gaza Strip. He emphasized the vital role of the UNRWA for Palestine refugees in the Near East in providing basic and necessary services for millions of Palestinians in the region, and called upon all states to ensure that the agency receives predictable, sustained, and sufficient funding to fulfill its mandate. Nicaragua invites you, members of the court, to join your voice, clad in its binding force, to those voices of the Special Rapporteur and the Human Rights Council, who, while they do have authority, do not have the binding force that yours does. This reasoning is also transposable mutatis mutandis to the support for other measures which Nicaragua is asking you to indicate. And it is also transposable since the dolus specialis, which is one of the conditions of the existence of genocide, which you have already judged plausible, is presented, obviously, is not considered relevant because of the serious breaches of international humanitarian law and human rights, which Germany has held to be responsible for. This is assuredly the case, when these arms are supplied because they can be used for committing serious breaches of international humanitarian law, as well as war crimes and the crime of apartheid, and Germany could only be fully aware of these risks and at least of their plausibility. These obligations clearly weigh on Germany and impose that Germany not offer assistance to Israel in these actions which are contrary to international law, but instead to mobilize all of their means, which they have at their disposal and continue to have at their disposal, to ensure the compliance by Israel of humanitarian law. It is even more crucial since Germany has great influence with Israel, thanks to the strength of the political links which unite these two states, links that Germany should avail themselves of at all times. Mr. President, Germany has done everything to repent for the Shoah, and this is to their honor. Germany is shocked that we even dare to accuse it of assisting in genocide and even of not scrupulously respecting international humanitarian law norms, which are also at stake in this case. Just as Israel, which is the Jewish state and the victim of the horrific Shoah, that Israel is appalled that we could accuse it of genocide. However, nobody owns the trademark of genocide. No state, not Israel, not Germany, can be free of the fundamental rules of international law under the pretext that they can defend themselves or aid the victim of such an attack to defend themselves. You must, members of the court, recall this with the means that are yours, the weapon of law, and this is what Nicaragua is asking of you. Mr. President, before asking you to once again call to the bar the Ambassador Arguello Gomez, the agent and counsel of Nicaragua, I would like to address to you, members of the court, my heartfelt thanks for your attention. I have often had the honor of taking the floor here in this great hall of justice, but I've rarely and perhaps never been so aware of the responsibility which is weighing on all of the actors here, not actors in a play, but actors in a judicial drama, which is playing out in this hall. This responsibility weighs on the counsel of the parties as it does on the court. Thank you.
Je remercie, Monsieur le Professeur Pelé.
Thank you very much.